Welcome to the South Dakota State Archives Basic Records Training Series, Part 4, Public Records Requests. South Dakota Codified Law 1-27-1 gives South Dakota citizens and other interested parties the authority to examine and receive copies of all public records. Government entities are required to make their records available to the public during normal business hours. There are a number of exceptions to the Public Records Law, which are in place to protect the privacy of individuals, property rights, and in some cases, public safety. Examples include records containing private information about individuals, such as personnel information or social security numbers, blueprints of public buildings, and locations of archaeological sites. The full list of exemptions can be found in SDCL 1-27-1.5. There are a few other important things to note about the South Dakota Public Records Law. First, the Records Law does not differentiate between record formats. Information stored digitally, paper records, audiovisual materials, maps, all can be subject to public records requests. Second, if someone requests information that your agency does not normally capture, you do not have to create a new record to fulfill the request. Also, you do not need to reformat the record to suit the needs of the requester. If the requested record is saved as a PDF, for example, you are not required to convert it to an Excel spreadsheet. Third, if a requested document contains restricted information, you may redact that information from the document before producing it. The document should be clearly marked so the requester knows information was removed from it, and justifications given in the response letter. Redactions are considered a partial denial of a records request, which can be appealed by the requester. So, how exactly does the South Dakota records request process work? The process begins with an informal request to the custodian of the record. So, for example, if someone contacts your office and asks to see your files on a specific project. If the request is extensive and takes longer than an hour to complete, then the requester may be required to pay for reproduction costs. If the request is likely to cost more than $50, you should provide a cost estimate to the requester. Most records requests end here. However, if the informal request is denied in whole or in part, a formal written request may be made to the Public Records Officer, which is usually the agency head. The records officer then has 10 days to respond to the request. They can provide the requested record, deny the request, ask for clarification, or acknowledge that the request has been received and give an estimate of the time needed to complete it. If the request is denied, the records officer must provide a written statement explaining the reasons for the denial. These letters should be kept permanently on file by the office. Within 90 days of the denial, a requester can file a written notice of review with the Office of Hearing Examiners to appeal the decision, or they can commence a civil action by summons. Thank you for joining us for Part 4 of our series. For more information on the public records request process, visit the Office of Hearing Examiners website at the URL on your screen. As always, if you have questions, please contact Sarah Casper at the State Archives or Dana Hofer with the State Records Management Office.